you're now our jury. So I'm going to give you a set of instructions in a few moments, but those instructions will include, don't discuss this case, don't talk about what it's about, don't try to hypothesize what you think the evidence will be, talk about anything you want to except this case right now. You should not let anyone else talk to you about it as well. If you were to leave out to go outside to smoke or something like that, the bailiffs will escort you out through a different doorway so that you don't come back through here because there may be something I'm having to take up that you shouldn't hear. So we're going to ask you to step across the hallway and we'll be in recess for about 15 minutes. When you come back, I'm going to give you this detailed set of instructions. So try to stretch your legs until then. So, all right, thank you. You may go. All right, before we break for our break this morning, I've been handed a motion to dismiss that Mr. Vaughn has written out by hand and is filed with, or is filing. I'm going to give it to the clerk to file and I need a copy of it run to give the state. And when we return for the beginning of this trial, I want to deal with that motion to dismiss on the record. So we'll be in recess for about 15 minutes. And then when we come back, the first thing we'll do is deal with Mr. Vaughn's motion to dismiss. Following that, I'm going to give the jury first set of instructions if I do not dismiss the case, obviously. And then we'll start with the evidence, opening statements, and then the evidence. All right, we'll be in recess. The jury back. I want to deal with this. Mr. Vaughn has filed a motion to dismiss. The motion states as follows: I, Sherrick Vaughn, affirm that the foregoing is true and the best of my knowledge under the penalty of perjury. I move the courts to dismiss for staleness of the prosecution, maliciousness, and lack of notice. Neither witness or trial was given notice more than 18 hours. This is clear prejudice against the defendant and a threat to justice. My prayer to the courts is for dismissal of this court for lack of due diligence, failure to follow notice rule of Tennessee criminal procedure. All right. This is one of the pending cases that has been pending for some time. It is certainly not a new case that's been suddenly brought. It is a case that was one of 4 cases, Mr. Vaughn, that you have had pending in this court. And as a result of that, certainly it is not a surprise or anything that that this case would be suddenly set for trial. When we were in court yesterday, I reminded you that you had filed a motion for speedy trial. And this is a failure to appear, which is not a complex case involving a multitude of discovery issues. It is simply a factual issue as to whether or not you did or did not fail to appear and whether or not there was any justifiable reason for it. And as a result of that, this court granted your motion for a speedy trial and set it for today. And at that point, yesterday, you voiced no opposition to it. And I asked you if you wanted to represent yourself and said, of course. So we are here today only because of the fact that you had requested a speedy trial. We're giving you a speedy trial on this issue. We'll work on the speedy trial for the remaining cases that you have. And but your motion to dismiss is respectfully denied, and we are ready to bring the jury in. Have the jury. Okay. Just hand them to them as they come in. I think Officer Howell may have mentioned that you can sit anywhere you want to now. There's no assigned seating since we are now past the jury selection. You can spread out a little bit since there's 4 seats on the end if you want to. It's up to you. All right, we're going to read you the initial charge. Ladies and gentlemen of the jury, the defendant, Sherrick Markey Vaughn, is charged in the indictment with the crime of failure to appear. The defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of these proceedings. I want to basically describe how the trial will be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision, but now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative worth or importance, rather. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant is charged in the indictment with failure to appear. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant had been directed to appear by a lawful authority, having been released from custody with or without bail on condition of subsequent appearance at an official proceeding at a specified time or place and knowingly failed to appear. The defendant has pled not guilty to the charges. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, and it says an attorney for the defendant, but the defendant representing himself may make an opening statement if he should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you've heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you to understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law you are to use in reaching your verdict. After you hear my instructions, I will select and excuse any alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence or to have his attorney or himself acting as attorney make any statements or arguments or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must consider the evidence in each count separately, and you must base your decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify. Then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to the witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of the witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused, and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon this fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question, or the reason that it could not be asked, please ask after court is adjourned, and I will attempt to explain it to you. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have any personal interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Did the witness seem to have a memory of the events that he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Was the witness distracted in any way? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make up your own evaluation of the testimony given by each of the witnesses and determine what weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You are not required to accept or reject everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness. In making up your mind and reaching a verdict, do not base any decision on the fact that there are more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I decide on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings relate only to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you're instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or a motion will be based solely upon the law. You must not infer from a ruling that I hold any view or opinion for or against any party in this lawsuit. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is that direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with a paper and pen if you decide to take notes. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. First, do not discuss the case among yourselves during the trial until I instruct you on the law and you start deliberating at the end of the case. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of the case would be premature and improper. Second, during the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. I apologize. Please do not talk with them about any subject whatsoever. You may see them in the hallway or on an elevator or at some other location. If you do, perhaps the best standing rule is not to say anything. Third, do not permit any other person to discuss the case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. I do not know if there will be any media reports in the newspapers, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decisions solely on the evidence you hear in the courtroom. You may not communicate with anyone or provide any information, photographs, or video to anyone by any means about the case on your cell phone, through email, Android, iPhone, text messaging, video, FaceTime, Google Duo, Zoom, Facebook, Messenger, Skype, through any blog or website, through any internet chat room, or by way of any other social networking websites, including but not limited to MySpace, Facebook, Instagram, Snapchat, Twitter, LinkedIn, TikTok, Meetup, Pinterest, Reddit, and YouTube, especially including the live stream of this trial. In keeping with the state of Tennessee's open access to the court's public policy, the majority of court proceedings are live streamed via YouTube. You as a juror are not recorded on video or shown on camera. You are not permitted to read, watch, or listen to those YouTube streams during the trial. You as jurors must base your decision solely on the evidence you hear in the courtroom. I will remind you of your duty and responsibility before all breaks in jury out hearings and trust you will follow my instruction in keeping with the integrity of the case and court proceedings. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. For example, do not visit the scene of an incident, read any textbooks or articles concerning any issue in this case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence the law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing, and in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your court officers who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1 for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full undivided attention to this case. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictment in this case. General Bryson.
In the Circuit Court for Dickson County, Tennessee, at Charlotte, September term, Grand Jury 2024. The grand jurors of Dickson County, Tennessee, duly impaneled, sworn, and upon their oaths do present that on or about July 24th, 2024, in Dickson County, Tennessee, and prior to the finding of this indictment, Sharik Marquis Vaughn, then and there, did unlawfully and knowingly fail to appear in the Circuit Court for Dickson County, Charlotte, Tennessee, as directed by the Circuit Court for the purpose of attending an official proceeding, to wit, trial date for docket cases 22 CC 2022 CR 336, 2022 CC 22 CC 2023 CR 227, and 2022 CC 2021 CR 462 in violation of Tennessee Code Annotated 3916-609 and against the peace and dignity of the state of Tennessee. Signed, W. Ray Crouch, Jr., District Attorney General.
Mr. Vaughn, to that indictment, how do you plead?
Not guilty, Your Honor.
Plea of not guilty is entered. The next step will be for the opening statements of the lawyers or of Mr. Vaughn, if you choose to do so. General?
Judge, I'll waive an opening.
Mr. Vaughn, do you wish to make any sort of opening statement?
No, sir.
All right. Opening statements have been waived. Therefore, the state may proceed with its proof. You may call your first witness.
State will call Pam Lewis.
Ms. Lewis, if you'll come forward, please.
Are you Pam Lewis?
Yes, ma'am.
And you are our Dickson County Circuit Court Clerk.
Yes, ma'am.
How long have you served as the Circuit Court Clerk?
Since 2002.
And what is the general duties of a Circuit Court Clerk?
General duties of the Circuit Court Clerk is to maintain the court records.
And either you or your staff are present for all circuit court dates.
Yes.
And in this case, we are here, Sharik Marquis Vaughn is on trial, and we're going to be talking about him. Is he here in the courtroom?
Yes, ma'am.
Could you point to him?
He's sitting at the defense table.
Judge, if the record would reflect that she's identified the defendant.
Record will so reflect.
And did the defendant have a trial date set on July the 24th of 2024?
Yes, ma'am.
Okay. And he had 3 cases set for trial that day?
Yes, ma'am.
And when someone has a trial date coming up, how do they know that they have a trial date coming up?
When they come to arraignment, we check to see if they need an attorney, and then they are given a plea date and a trial date.
And what was the date of the immediately preceding court date for the defendant? So when was the last time he was in court before that July 24th trial date?
July 19th.
And that was here in Dickson County.
Yes, it was before Judge Lockard Mash.
And he needed to appear in the same courtroom that on July 19th as he was on July 24th.
Yes, ma'am.
And was his court date announced on that July 19th date?
Yes.
Now, would he have known about the trial date before that July 19th date?
Yes, he was notified in March of 2024 when Attorney Flanagan filed a motion to withdraw his counsel.
So he was aware of the court date in March and then was in court, let's see, the 19th to the 24th, 5 days before his trial date.
Yes.
Now, on the date of a trial, such as the one scheduled on July 24th of 2024, does your office bring in a jury panel?
Yes, ma'am.
And was a jury panel brought in for this trial?
Yes.
And did the defendant show up for his court date on July the 24th of 2024?
No, ma'am.
And you have reviewed all 3 docket sheets for all 3 cases listed on the indictment?
Yes, ma'am.
And he was not present?
He was not present.
Judge, that's the state's questions for this witness.
Mr. Vaughn, do you have questions you want to ask of this witness?
I do.
All right.
Good morning.
Morning.
Okay, I believe you just stated to Ms. Bryson that your job title is to maintain court records.
Yes, sir.
Okay, what type of records are they? Like,
We have criminal records, civil records.
okay. Okay, are you biased against me?
No,
You are not?
no.
Okay. Do you recall speaking to, are you familiar with who Scott Tummins is?
Yes, he's a bondsman.
Yes, he's a bondsman. Did you happen to speak to him at the time when I was alleged not to appear?
No, sir.
Okay, I don't have it with me. I have, on some of your records, it says that you spoke to Scott Tummins and as well to Lee Spratt. You not recall your record saying that?
No, sir.
Okay, it says that, that the copy I have, that you spoke to Lee Spratt and Lee Spratt spoke to you and said he had no contact with me.
That was the day of the trial. He announced he had no contact with you.
Okay, is Lee Spratt my elbow counsel?
He was, yes, sir.
He was my elbow counsel?
Yes, sir.
So he can make statements on my behalf and testify on my behalf?
Yes.
He can, without my lead?
No, not
Oh.
without your permission.
Okay, so he did that free will?
I guess so.
Okay, you said that you keep a record of everything filed into this court. Have I ever filed a complaint against you?
No, sir.
Have I
Nothing.
filed any paperwork to have you recused or anything in this court?
Yes, I do believe you did.
Okay, I did. Okay, was I ever charged with another failure to appear out of this court?
I don't believe so. Not that I remember you haven't been.
One that I back, I want to say last year, and I was released upon out of this court.
Let me think. On July 19th, the day you was here, that Judge Lockern Mash reinstated to your bond. That was the day they dismissed the first one because you gave reason why you did not show up the first time.
Correct.
That was prior to the July 24th.
Correct. And
Yes.
what was the reasoning for that one?
I do not remember what reason you gave.
Could it possibly been some messed up paperwork?
It could have been.
Okay, what about this time? Do you think that could have possibly been?
No, sir. No, sir.
Your Honor, that's all.
Redirect.
No, Judge.
Thank you, Ms. Lewis. You may step down. May she resume her duties if she wants to. You want her at the table with you. Go back to the table and have a seat. State may call your next witness.
Judge, that will be the state's case in chief.
State has rested their proof, Mr. Vaughn. Ladies and gentlemen, if you'll step across the hallway for a moment, let me take up one matter. All right, Mr. Vaughn, if you'll come to the podium, please. Mr. Vaughn, the state has rested their proof, so the next question is whether or not you want to present any proof. I want to go through your rights as a defendant to make sure you understand what your options are. We did this at the last trial, so I'm sure you're familiar with it. But I'm going to ask you to raise your right hand and let me place you under oath for the sole purpose of this examination. All right.
Fine.
Mr. Vaughn, you are representing yourself, but even as a defendant representing yourself, you have the right to testify at a trial, at this trial. And if you choose to testify, then no one can stop you from testifying if you want to give your version of the events and so forth. Likewise, you are not required to testify, and no inference of guilt will arise if you choose not to testify. No one can make you testify if you don't want to testify. So the question becomes, do you wish to testify at your trial, or do you want to waive your right to testify?
I'll waive it.
You're going to waive your right to testify?
Yes, sir.
All right, then have a seat. Bring the jury back. I'm sorry. Okay. All right, ladies and gentlemen, the state has now rested. Mr. Vaughn, you as the defense have the right to present proof. Do you wish to put on any proof?
No, sir.
All right, then the state has rested, the defense has rested, so you will now hear if there's any closing arguments that the sides wish to make, then you will hear from them.
Ladies and gentlemen, this is probably the shortest jury trial that has happened in this courtroom. It's okay, you don't have to. The defendant is charged with failing to appear on his trial date, July 24th of 2024. You have heard testimony that he was in this courtroom on July 19th, just a few days before that, where he would have known of his court date, and that just a few days later, he failed to appear for that court date. And as such, the state will ask you, you're going to receive instructions from the judge and a jury verdict. You'll go back and elect a foreman, and the state will ask you to return a guilty verdict for failure to appear. Thank you.
Mr. Vaughn, you have the right to address the jury, but you may not testify. You may only argue about the facts.
You just heard me ask the witness multiple questions about whether she was biased and whether I filed a complaint against her. She testified that I have. You've also heard that I've been charged with failure to appear at this court before too, and it was also dismissed. You've also heard that I've asked the witness whether there has been errors made before in my case, and you also heard her state yes. I'm asking y'all to take this and do the best y'all can. Thank y'all.
State has the final say if you wish.
Judge, I'll waive.
All right, and ladies and gentlemen, we have a final set of instructions to give to you. All right, ladies and gentlemen, this will be the final charge of the court. The defendant, Sheriff Marky Vaughn, is charged in the indictment with the crime of failure to appear. The defendant pleads not guilty to the indictment and the offense contained therein. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability, after such investigation, to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Dickson County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Dickson County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. As heretofore stated in the indictment, the defendant is charged with the crime of failure to appear. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly failed to appear, and 2, that the defendant had been directed to appear by a lawful authority, and 3, that the defendant had been released from custody with or without bail on condition of subsequent appearance at an official proceeding at a specified time or place. Custody means under arrest by a law enforcement officer or under restraint by a public servant pursuant to an order of a court. Official proceeding means any type of administrative, executive, legislative, or judicial proceeding that may be conducted before a public servant authorized by law to take statements under oath. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find the defendant guilty of a failure to appear as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreman or forelady will announce it. In reaching your verdict, you shall consider the offense charged in the indictment. If you unanimously find the defendant guilty of the offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to the defendant. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. If after your deliberations you find the defendant guilty, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. You may now retire to begin your deliberations. Ladies and gentlemen, I have prepared a verdict form that will go back with the original of the charge, and it simply finds a place. It just provides that in the indictment for the charge of failure to appear, we, the jury, find the defendant, Sherrick Mark Vaughn, either not guilty or guilty, and you check one and the foreman signs it. So, ladies and gentlemen, if you will step across the hallway, you may begin your deliberations. This will go back with it. Right, while we were here, General, we have discussed trying to conduct another one of Mr. Vaughn's trials on the 23rd and 24th of this month.
Yes, Judge, one of my victim witness coordinators is calling this morning to all of the witnesses in the simple assault case to confirm their availability for that trial. I've not had a chance to see if she's got in touch with everyone.
As soon as you know anything, if you can find out before we are adjourned today, I would appreciate those. Mr. Vaughn needs to know if he's going to trial on the 23rd and 24th.
Is my witness still to need to be subpoenaed for
Which
that?
witness is that?
Jennifer Dozier, I placed in a motion for her to be at every one of them, every pending case.
I don't know. We need to make sure that Ms. Dozier was subpoenaed for this trial, the next trial. Problem is we don't have a trial date, so it's hard to subpoena somebody to let them know they have to be somewhere when we don't know what the trial date is. But there should be a subpoena issued for her. Is she still in Savannah?
Yes.
All right. All right, Mr. Vaughn, if you'll step back with the officers, we'll bring you out when the jury is returned.
I have a quick question, if I could, Your Honor. This is about yesterday, if I can just gain some clarity.
All right.
I haven't had the chance to go through that paperwork yet. Was a transcript in that paperwork?
A transcript of what?
Of the proceedings. Was that in that
Are you
paperwork?
talking about a typewritten transcript?
Yes, sir.
No, that was not provided. What was provided was the entirety of your file here in the court. As far as if you're asking for a transcript of every time you appeared in court, that will be a lengthy procedure to have to identify what days we're talking about. Then the court reporter would have to have a sufficient length of time to type everything up, which will be a very difficult thing for her to do on a short-term situation. So. Okay. All right. right, so there's an order granting you a transcript, but you don't have it yet.
For which days, Your Honor?
Well,
All right, thank you, Your Honor.
thank you. Thank you. Okay. I appreciate it. All right, well, we'll take a recess until the jury returns. All right, jury has reached a verdict, so we're gonna bring in Mr. Vaughn and we'll find out what the verdict is. All right, bring the jury in. All right. All right, ladies and gentlemen, I'm told that you have reached a verdict. Is that correct? Will the foreman please stand and announce as to the indictment, the charge of failure to appear, how does the jury find the defendant? Guilty or not guilty? All right, is this the unanimous verdict of all, if you will, signify by raising your right hand? Show that all jurors have signified that this is a unanimous verdict. Thank you, ladies and gentlemen. We're going to dismiss you now, but thank you for your time and attention. As I explained to you, every person has a constitutional right to try a case that they're charged with before a jury if it involves any type of incarceration. So the fact that Mr. Vaughn tried this case today just means he was exercising a constitutional right that we give every defendant. Thank you for your time and attention, and we're going to allow you to be discharged. I wish I could tell you you don't have to answer the call the next time, but we need you to check that number after 6 p.m. on the 22nd for possible service on the 23rd. And you may free to go. If you'll exit through this door, there's another exit they can let you. If there's anything you have that you need to get out of the jury room, please do so. Thank you. All right, we have set a sentencing hearing on Mr. Vaughn's other charges on January the 28th, so this case will also be combined for sentencing on that charge as well. And we are trying to determine whether or not it's possible to try one of his other cases on the 23rd, and I assume you're going to have to check and all right. Let us know as quickly as possible. Mr. Vaughn will get word to you at the jail as quickly as possible once we know that the trial on the 23rd is going to go forward. So that will be for the simple assault.
Yes, Judge.
Would that be like, you gonna send me a letter or something?
Actually, I think, yes, they'll have to send you a notice at the jail from, where are you housed, in Decatur?
No, I'm here.
He's here.
I've been here.
Judge, I will, I normally, when I'm dealing with an attorney, I normally copy that attorney on my email to the clerk for my witness list. And so I will write Mr. Vaughn a letter confirming and giving him a formal witness list.
Okay.
All right.
All right, so we have, right now, as far as the cases that remain of Mr. Vaughn, we have two more indictments, is
Well,
that correct?
we'll still have to go back and try the driving on revoked.
Well, we could do that on the 23rd if nothing else, couldn't we?
Yes, Judge, I should be able to do that. I'll check with Officer Javen.
That's the driving on revoked third offense that he withdrew his guilty. I was allowed him to withdraw his guilty plea.
Yes, Judge. And, I mean, I could probably try those. I mean, if I try one on the 23rd, I can try the other one on the 24th.
I think that would be a good plan. So, all right. Then we'll let you know as soon as possible, Mr. Vaughn, whether we're going to be trying some more. We can expect to try at least one of those cases, the driving on revoked license, on the 23rd or 24th, depending on one of those 2 days. Just expect you're going to go forward on your driving on revoked license that I allowed you to withdraw your plea on, and that will take place. We'll need to make sure that it's a separate jury panel. So. Correct. All right. Mr. Vaughn will be remanded to the jail until his next trial date. We stand adjourned.